Title IX of the Education Amendments of 1972 is a pivotal federal civil rights law in the United States that prohibits sex-based discrimination in any school or other education programs that receives federal funding. This legislation was a significant advancement in ensuring gender equality in education. Historically, before Title IX, discrimination based on sex was prevalent in educational institutions. Opportunities for women were often limited. Women faced barriers in accessing educational programs and scholarships, and there was a significant disparity in funding and resources between men's and women's sports programs. The passage of Title IX was driven by the broader women's rights movement and the growing awareness of gender inequality. The law was enacted on June 23, 1972 as part of the Education Amendment and signed into law by President Richard Nixon. Title IX states, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education programs or activity receiving federal financial assistance." This broad mandate covers a range of issues from admissions and recruitment and athletics and sexual harassment. The impact of Title IX has been far-reaching. It has been instrumental in increasing the participation of women in sports and higher education, ensuring equal treatment in academic programs, and addressing sexual harassment and violence in educational settings. Compliance with Title IX is overseen by the Office for Civil Rights in the Department of Education. Let's first look at Title IX and interscholastic sports, which have two major areas: the integration of single-sex teams and unequal treatment of males and females. Title IX does permit the separation of students by sex within contact sports like wrestling, rugby, ice hockey, football, basketball, and others that involve physical contact. However, individual school districts have the discretion to decide whether to allow co-educational participation in contact sports. The overarching goal of Title IX is to ensure equal athletic opportunities for males and females. If a school or university chooses to have mixed gender teams in contact sports, they cannot discriminate against athletes based on their gender. All athletes must have an equal opportunity to join the team, receive proper coaching, access facilities, and participate in games and practices without facing any bias or unfair treatment. For example, if a college decides to have a co-ed soccer team, they must ensure that both male and female players have the same opportunities to be part of the team, receive the same level of training, and are treated fairly in terms of playing time and resources. In the case Parker v. Franklin County Community School Corporation, Amber Parker and Tammy Hurley, representing their daughters, sued several Indiana schools over unequal treatment in girls' basketball. Initially, Parker, a former coach, and later Hurley, a parent, highlighted the issue at Franklin County High School. The lawsuit involves 14 schools, some from the Eastern Indiana Athletic Conference and others outside it. At Franklin County, girls' games start 2 weeks before the boys' season, enjoying primetime slots and large crowds. But once the boys' season begins, girls' games move to less popular weekdays, generally Monday through Friday, to give a preference to boys' Friday and Saturday night games. This leads to a loss of audience, conflict with homework, and the girls' feeling of inferiority. During the 2009 and 2010 season, nearly 95% of boys, but only about 53% of girls' games were in prime time. The school's athletic director, Beth Foster, tried to balance this but faced resistance from other schools' directors. The contracts governing game schedules, typically set for 2 or 4 years, also limited the changes. The court noted that the significant disparity in scheduling boys and girls basketball games has persisted despite awareness and previous warnings. In 1997, the Office for Civil Rights had already expressed concerns about Indiana's scheduling practices, emphasizing that unequal scheduling could violate Title IX. The OCR highlighted that given boys' games primetime slots without a valid, undiscriminatory reason could be discriminatory. Traditional scheduling practices or conference agreements were not considered valid justifications for this disparity. One thing I want to point out here is that I've often heard administrators justify their violation of policies and procedures by saying, "We've done it in the past," or "the past leadership team has done it." This is never a valid justification. Just because the policy was violated in the past does not mean you should continue doing so. 2 wrongs don't make it right. Part of your job is to uphold rules and standards consistently, regardless of historical practices. Let's come back to the Parker case. The court found the scheduling practice at Franklin High School and other schools resulted in harms to female athletes, including academic burdens due to more weeknight games, reduced school and community support, and psychological impacts like feelings of inferiority. The different scheduling treatment suggested that female athletes were less valued than their male counterparts, influencing their interest in sports and perpetuating gender stereotypes. As a result, the scheduling practice amounted to discrimination under Title IX. The court's decision emphasized the importance of equal treatment and opportunities in school athletics, recognizing the broader implications of such disparities on gender equality and the development of women's sports. Allegations of gender bias in public schools and universities extend beyond athletic programs. Differential treatment of males and females in academic courses and educational institutions have also been challenged in courts. Under Title IX, the presence of single-sex academic programs may seem contradictory to the law's emphasis on non-discrimination based on sex. However, Title IX does allow for certain exceptions where single-sex programs can be justified and are legal. Those exceptions are typically based on specific educational objectives and conditions that ensure fairness. If a single-sex program is offered, an equivalent program must be available to the other sex. This does not mean the programs must be identical, but they should be comparable in quality and content. Participation in single-sex programs should be voluntary, not mandatory. This allows students and their families to choose the educational setting that they believe is most beneficial. Importantly, those programs should undergo regular evaluations to ensure they are compliant with Title IX and their educational benefits justify the single-sex format. Next, let's move on to sexual harassment, which includes employee-to-student harassment and student-to-student harassment. Over time, the interpretation of Title IX has expanded to include protections against sexual violence and harassment. In 1997, the U.S. Department of Education's Office for Civil Rights issued a sexual harassment guidance, harassment of students by school employees, other students, or third parties. The guidance clarified that sexual harassment constituted discrimination under Title IX. This guidance emphasized the responsibility of educational institutions to address sexual harassment to comply with Title IX. I'll discuss employee-to-student harassment in a different video. Here I focus on student-to-student harassment. To decide whether schools are liable for student-to-student harassment under Title IX, the courts usually ask 3 questions. First, did school officials know about the harassment? Second, did school officials reflect the deliberate indifference toward the victim? Third, was the harassment so severe, pervasive, and objectively offensive that it interfered with the victim receiving educational benefits? Let me introduce 2 cases. In Davis v. Monroe County Board of Education, 1997, LaShonda was a 5th grader at Harbor Elementary School in Monroe County, Georgia. From December 1992, a classmate, GF, began sexually harassing her. He attempted inappropriate touching and made vulgar comments. LaShonda reported the incidents to her teacher and her mother, who informed the school. Despite the reports, the school did not take disciplinary action against GF. The harassment continued for months, including incidents during physical education class and other settings, each reported by LaShonda and her mother to different teachers and the school principal. However, the school's response remained inadequate. LaShonda's academic performance declined, and she even wrote a suicide note, indicating the severe impact of the ongoing harassment. Other girls also experienced similar behavior from GF. A group of female students attempted to report this to the school principal, but their efforts were dismissed. The school did not take serious steps to address the situation. Even when LaShonda's mother spoke to the school principal, his response was dismissive, and he questioned why LaShonda was the only one complaining. It took months before LaShonda was allowed to change her seat away from GF. The school district at the time lacked a clear policy or training for handling peer sexual harassment. Ultimately, in May 1994, LaShonda's mother filed a lawsuit against the Monroe County Board of Education, the school district superintendent, and the school principal, highlighting the school's failure to adequately address and prevent the sexual harassment. The case eventually reached the Supreme Court. The court concluded that the school board had actual knowledge of the harassment, as it was reported to teachers and the principal repeatedly. Despite multiple reports of harassment to teachers and the principal, the school did not respond in a manner that was adequate to address or prevent the harassment. An adequate response by the school means taking effective and timely action to address and prevent the harassment. This could include investigating the reports thoroughly, implementing disciplinary measures against the harasser, providing support to the victim, and ensuring the educational environment is safe and non-discriminatory. The school's failure to take such steps, despite being aware of the harassment, was seen as a clear instance of deliberate indifference, making the school potentially liable under Title IX. Moreover, the Supreme Court found the harassment to be sufficiently severe, pervasive, and objectively offensive because it created a hostile environment that interfered with the victim's access to educational opportunities. The harassment was not an isolated incident, but a repeated, ongoing pattern that affected the victim's emotional and psychological well-being, as well as her academic performance. The Supreme Court's decision emphasized that such an environment can impede a student's ability to participate or benefit from educational programs. As a result, the school was liable under Title IX. Let's look at a more recent case. In the case KS v. Northwest Independent School District, 2017, KS was a sixth grade student who faced harassment at school due to his physical appearance. He was bullied and physically harassed by peers, which was reported to the school administration. Despite some actions by the school, like advising KS to visit the counselor and monitoring the locker room, the harassment continued. The perpetrators were at times disciplined, but not always. Sometimes KS was thought to be at fault, and he was disciplined. Sometimes both KS and others were disciplined for the same altercation. There were a few fairly intensive investigations in which multiple student statements were taken, which led to different variations of discipline. KS experienced depression, attempting suicide once. In January 2011, the school decided to proceed with a psychological evaluation of KS, told teachers to monitor KS both in the class and hallways, provided counselors to escort KS to and from the restroom, and required KS to sit behind the bus driver to avoid altercations on the bus. That same day, though, KS and his mother decided to withdraw from the school and moved to a different state. KS later filed a lawsuit against the school district. The court noted that the school district took some action in response to the incidents, including investigating complaints, reprimanding or suspending students, and talking to the involved parties. The court determined that those responses, while not always effective, did not demonstrate deliberate indifference. Although the school's response to the harassment was not completely effective, they were not so unreasonable or inadequate as to constitute deliberate indifference. In other words, the school did take some steps to address the harassment, and those steps were deemed reasonable under the specific circumstances of the case. Moreover, the school district not following internal policies or federal guidelines alone does not meet the high standard of deliberate indifference in legal terms. This standard requires clear evidence of a school's unreasonable inaction or inadequate response, despite being aware of the harassment. In this case, the school's failure to strictly adhere to all policies and guidelines was not seen as sufficiently negligent or unreasonable to qualify as deliberate indifference. The court looked for stronger evidence of negligence or mismanagement in handling the harassment situation. In this video, I introduced three major areas of Title IX in education: interscholastic sports, academic programs, and sexual harassment. All of the cases I shared in this video highlight the importance of understanding and properly implementing school policies and federal guidelines regarding Title IX. Here is my question for you. Review your institution's Title IX policies and procedures. Identify areas where the policies could be improved to more effectively prevent and address harassment issues. Consider aspects like clarity, accessibility, prevention strategies, training for staff and students, reporting mechanisms, and support systems for victims. What are your findings and proposals? Feel free to leave your comments below. Thanks for watching. I'll see you next time.